Do you have an invention for which you want to get a patent? Do you already have a patent and want to know what is protected? I'm going to talk about a few aspects regarding what patents do and don't protect now. At a very basic level, a patent allows you to control who can make, use, or sell your patented invention. There are three basic types of patents: utility, design, and plant. Depending on which type of patent you get will determine what protections you get. I generally assume utility patents, because most of the time that is what you'll be interested in. Let's start off with what a patent doesn't protect before we proceed to what it actually provides for a patent holder. Some think a U.S. patent protects them in foreign countries, or that they need a U.S. patent for operation in foreign countries. This is not the case. The U.S. patent does not have any power in England or in any other country, except insofar as it may buy time for you to file for a patent in those other countries according to international patent treaties. But by itself, the U.S. patent doesn't protect your invention in any other country besides the U.S. and its territories. It is a misconception if you think the U.S. patent protects you in England, France, or China for that matter. Let's narrow down our discussion with an example. Pretend you have a patent on a new kind of mechanical pencil in the U.S., but not in any other country. We'll also say that the time has expired for getting a patent in all of these other countries just to keep things simple. Now let's say that a German company has a factory in Germany which makes your exact mechanical pencil, copying every critical new feature in your U.S. patent. I have nothing against Germany or German companies. I'm just picking an economically important country that isn't the U.S. They advertise it as their fantastic new pencil, put their logo on it, and start selling it in Germany. Can your U.S. patent help you? No. Let's say they make your pencil in Germany and export it to England. Can your U.S. patent help you? What do you think? The answer is no. So what does a U.S. patent protect if others can make and use your invention? There are several aspects to this question. First, as we look at it in contrast to the above, a U.S. patent gives you power in the U.S. and its territories. This power applies to things made in non-U.S. countries or for processes used which infringe active U.S. patents, but only if those are imported into the U.S. or exported from the U.S. Let's look at the same example above. This German factory which is making your pencil now tries to export it from Germany into the U.S. Perhaps their sales agents who work for the company didn't even know about your U.S. patent because they thought it was their pencil. At this point, your U.S. patent is useful. You can stop them from importing that pencil into the U.S. in principle. You can sue them for infringement. If they were knowingly in violation of your patent, they could be liable for more than just actual damages. Of course, you'd have to work with a U.S. attorney on such matters. Now, let's say a Japanese company which is good at making pencils wants to manufacture your pencil in America, but not sell or market your pencil in the U.S. They want to make the pencil here but ship everything to China. Is your U.S. patent useful? Yes. In principle, your U.S. patent can be used to stop them from making your pencil in the U.S., regardless of whether or not that pencil is for export. While your U.S. patent doesn't give you the right to make your pencil, even in the U.S., it does give you the right to stop anyone else from making your mechanical pencil here in the U.S., or importing that mechanical pencil from anywhere else in the world into the U.S. Thus, you can't stop the German factory from making a product in any other country in the world, importing or exporting that pencil to or from any other country, or to selling or using in any other country. It does give you power whenever that company wants to do something with your pencil in the U.S. Now let's switch our focus and look at the content of the patent itself, because not all of it provides power for you to stop others from making, using, or selling your mechanical pencil. Firstly, some think that if they talk about an idea in their patent, it is automatically protected. This is not the case. Much of the information in a patent is not necessarily new to the world. Almost every invention is a combination of preceding inventions or knowledge with a new or useful feature or process. Let's take another look at your hypothetical patent again. Let's presume, for the sake of argument right now, that the critical aspect which makes your pencil new is a silicon plunger. Let's also say your patent talks about a clip and a tubular body which holds the pencil lead. The clip and the body have already been invented and are common knowledge. Your patent talked about these things as part of making your mechanical pencil a reality. Yet the clip and body are not the invention by themselves. Thus, they are not protected by the patent, even though discussed or shown in the patent. They might, however, be protected in combination with your silicon plunger. Secondly, only one portion of the patent is designed to communicate what you are asserting as protected. One explicit part of the patent notifies the world what you are stating as your intellectual property. That part is the claims section of the patent. Again, the portion of the patent which provides proactive power for you to stop others from using your invention must be in the claims section of your patent. The rest of the document doesn't give you assertive power except insofar as it relates to explaining what is in the claims. Let's recall the silicon plunger in your patent. If your patent talked about a silicon plunger, but your claims section does not, then the silicon plunger is not explicitly protected. Because not everything talked about in an invention is your contribution to the world, and yet those things must be communicated in a patent, I hope you can see why your intellectual property needs to be stated explicitly. This is what the claims are all about. While the technicalities of the patent system may at times seem unfair or unreasonable, I hope you can at least begin to understand why the claims section provides the protected space for the patent and not the whole document. In conclusion, a U.S. patent provides protection in the U.S. only. Each country has its own patent system, and patent protections desired from these must be sought in each respective country. The claims section tells the world what is yours. Claims provide for your protected space. Please read the description for disclaimers. I hope this video helps you. I am a U.S. patent agent. Please see www.patentcast.net for more information if you would like to contact me. Regardless, if you liked this video, would you please consider giving it a thumbs up and sharing it with your friends. Please leave your comments below.